My name is Stephen O'Regan. I am an associate in the International Business Advisory Department at Dezan, Shira & Associates Guangzhou office. Dezan, Shira & Associates is a pan-Asia multidisciplinary professional services firm providing legal, tax and operational advisory to international corporate investors. We are operational throughout China, ASEAN and India with our mission to guide foreign companies through Asia's complex regulatory environment and assist them with all aspects of establishing, maintaining and growing their business operations in the region. Today we'll be discussing triggering and implementation of mass layoffs in China. It is an unfortunate realization to some companies that they are faced with the prospect of closing the doors in their business or downsizing to match economic realities. In either case, the company must figure out what to do with the staff that they wish to dismiss. If the number of staff being dismissed reaches a certain threshold, then the company would qualify for a mass layoff. A mass layoff is defined under Article 41 of China's Labor Contract Law as being when a company terminates the labor contracts of at least 20 employees or a number of employees equal to 10% of its total workforce, whichever of these figures is lower. A mass layoff is an extremely delicate process that involves a certain bureau of the government to consent to. If the mass layoff is not implemented properly, the government may apply penalties and the employees may also claim additional compensation if their contracts have not been terminated in the appropriate way. A company may apply for a mass layoff under the following scenarios. It is under restructuring according to the Enterprise Bankruptcy Law. It encounters serious difficulties in production and business operation. The enterprise changes the products that it used to produce, makes important technological renovation, or adjusts the method of its business operation, and it is still necessary to lay off the number of employees after changing the labor contract, or the objective economic situation on which the labor contract is based has changed considerably and the employer is unable to perform the labor contract. 3 of these 4 conditions have been left relatively vague in the labor contract law, which gives the courts quite a lot of discretion concerning how to define them. Foreign enterprises can expect the interpretation of these terms to vary quite widely across different areas of the country. Handling employees during a mass layoff is quite tricky, as the process basically removes the rights for double compensation. Normally when an employee is unlawfully fired, they are entitled to double compensation than if they were simply laid off. And now it is increasingly common for Chinese employees, either individually or en masse, to deliberately misbehave in order to pocket more compensation. We've had cases where employees fake illnesses, hold company chops hostage, and completely interrupt production in factories, and they do this with complete impunity and without fear of losing their jobs. Now, there are some employees who are protected during mass layoffs. For example, a company is not allowed to lay off an employee who has engaged in operations which will expose him to occupational disease hazards and has not undergone an occupational health checkup before he leaves his position, or is suspected of having an occupational disease and is under diagnosis or medical observation, has been confirmed as having lost or partially lost his capacity to work due to an occupational disease or a work-related injury during his employment with the company, has contracted an illness or sustained a non-work-related injury and the prescribed period of time for medical treatment has not expired, is a female who is pregnant, in confinement or a nursing period, has been working for the company continuously for not less than 15 years and is less than 5 years away from his legal retirement age, or is in other circumstances under which the company shall not terminate the labor contract as prescribed by law or any administrative regulations. There are also employees who have a priority to stay. During a mass layoff, the following employees will have priority of staying with the company: those who have special technical expertise, those who have concluded a fixed-term labor contract with a long time period until the expiry of the contract, and those who have concluded a labor contract without a fixed term, and those whose family has no other breadwinner and has the aged or minor dependents to support. Regarding compensation in mass layoffs, under the PRC Labor Contract Law, the general rule for calculating severance compensation in a mass layoff is as following. The employer should pay 1 month's salary for each year of employment completed by the employee. For the period of employment of less than 1 year but more than half a year, such period will be treated as 1 year's employment. The monthly salary should be the wages, which includes salary, bonus, subsidies, and other monetary remuneration of the employee averaged out over 12 months prior to the termination, or 3 times the local average monthly salary of the city, whichever figure is lower. However, if the mass layoff cannot get the approval from the Labour Bureau, the termination of the employment contract between the company and the employees will become termination without legal cause, in which case the amount of severance compensation to be paid will be doubled. Employers should be aware that there may be implications with unpaid social insurance of their employees if they wish to terminate through a mass layoff. Arbitration in courts usually will not accept cases where the employee claims for underpaid social insurance, but will direct the employee to file a complaint with the Social Insurance Collection Authority, which is entitled to require the company to make up the difference at any time without statutory time limits. However, in practice, the Social Insurance Collection Authority may only allow a company to make up the difference of a few months, depending on the local practice, which could vary by time and region. However, if the employee fails to claim social insurance treatment as a result of the underpaid social insurance contribution, the company will be liable to compensate the employee for the loss of the social insurance treatment. To take an example, if the company does not pay the medical insurance in full amount and the benefits that the employee may enjoy from medical insurance funds are downgraded accordingly, the employee may claim the part of benefits deprived due to the underpaid medical insurance from the company. Now, in practice, there is no immediate solution to this. If the company brings this up with the employee usually will require the company to either make up all the past difference with the Social Insurance Collection Authority or pay those amounts to the employee personally. If the company wants to make up the past difference with the Social Insurance Collection Authority, the employee will also need to contribute his or her own parts. If the employee is unwilling to do so, the company will have to pay both the company's and the employee's contribution at its own cost. Essentially, the Social Insurance Collection Authority only allows the company to make up the difference for a short period, which could make it impossible for the company to fully correct the underpaid social insurance issue. If the underpaid amounts are all paid to the employee, it is arguable whether the company could be legally released from the obligation to make up the underpaid social insurance contribution to the collection authority. However, we cannot rule out such possibility that the Social Insurance Collection Authority still goes after the company for the underpaid social insurance contribution. Despite this, in practice, if the employee does not file a complaint, it is still rare for the Social Insurance Collection Authority to take initiatives and go after the company. The company may need to respond quickly to any request made by the employee in relation to social insurance contribution during the termination of their employment, no matter in a mass layoff or a termination without legal cause. If the severance compensation budget allows, you may wish to set aside a provision for the underpaid social insurance. The stages of a mass layoff can be summarized in 4 key points. Point 1. The company explains the circumstances of the mass layoff to the employees 30 days before the intended implementation of the layoff. Step 2. The opinion of the employees are taken into account by the board of the company. Step 3. The company reports the implementation of the mass layoff to the local Labour Administration Department. And Step 4. Once the 30-day period expires, the mass layoff can be implemented. I'd now like to briefly take you through a timetable of the mass layoff procedure. During the first couple of days, the company needs to collect the employee information, and they need to collect all information that is relevant and pertains to the target employees that will be a part of the mass layoff. In week 1, they need to assign a team to execute the mass layoff, and it is vitally important that the team be internal staff with experience in HR and finance. In week 2, they need to finalize the mass layoff employees and assess the employees' entitled remuneration. During week 3, the company should consult with the Labour Bureau and acquire comments whether the company is permitted to conduct a mass layoff. The consent and knowledge of the Labour Bureau is all that is needed. And then they need to formulate a mass layoff plan, which should include severance compensation plans, employees list, background information, and relevant details pertaining to the mass layoff. By day 20, they should issue the notice for a general meeting with all employees. The meeting should be held 30 days in advance of the official termination of the employment contracts. Employees should be notified, and the meeting with the employees should be taken with caution and left to the discretion of the company. By day 24, the general staff meeting and finalization should be implemented. The employees should sign for attendance in the meeting, Meeting notes should be taken. Information should be disseminated and made clear to the employees. And this is a chance for open feedback and discussion with all parties involved. By day 30, they need to report finalization plans to the Labour Bureau, and this should include multiple pieces of information, including reasons for the mass layoff, the name list, contact information of those in charge, salary and social insurance information. By about day 55, which is 30 days after the general meeting, the company can then implement the mass layoff and pay out severance, salary and other remuneration. It is also important to keep a backlog of all files involved and provide employees with whatever documents they have the right to be given. At about 2 months or 60 days in, we will talk about the completion of the mass layoff plan and report to the Labour Bureau if needed. So this brings us to the conclusion of this webinar. Should you have any questions or require further assistance, please don't hesitate to contact us at the email address provided below.